Dear students, very good morning to all of you. I hope you all are in fine health and you are taking your studies very seriously. So, dear students, now as you all know that we are revising our syllabus. Until yesterday, we had revised our 4 chapters. So, today we are to start revising 5th chapter, that is law. But before starting this chapter, let's take quick recapitulation of what did we revise yesterday. Okay, so we started revising from question number 4. Acting according to the Hobbesian tradition, John Austin formulated a legal theory of sovereignty in his work Lectures on Jurisprudence. So, with reference to his work, explain the features of his legal theory. So, let's pause this video for 1 minute and revise this topic in your mind. So, next question. Explain the features of pluralist theory of sovereignty. So, you are to revise the features of pluralist theory of sovereignty. So, pause this video for 1 minute and revise this topic. Next question is, it is a picture based question. In this picture given, Prime Minister Modi of India is meeting President Putin of Russia. So it is a picture, you can well assume Mr. Prime Minister of India and Mr. President of Russia, they are shaking hands with each other. So based on this picture, question number 1 is, how does the picture shown above depict a dimension of sovereignty? So which dimension of sovereignty is depicted here? Question number 2, with the help of a relevant example, outline any other significant dimension of sovereignty. So, what is the another dimension of sovereignty? It is internal sovereignty. So, I hope you have all revised these topics. So, today we will start revising chapter number 5, law. In this chapter, we are to revise the meaning, sources, and kinds of law. So before starting this chapter, let's read about law, what the law is. So the word law, it has been derived from Teutonic word lag, which means definite. So the word law, it has been derived from a Teutonic word lag. Teutonic means German, okay, which means definite. On this basis, law can simply be defined as a definite rule of conduct and human relations. So on this basis, we can define law as a definite rule of conduct. Law prescribes general conditions of human activity in state. So what does law prescribe? It prescribes general conditions of human activity in state. So we all are the citizens of state, and what we need to do while we are the citizens of this state, it is prescribed by the law. So law prescribed what is to be done or what is not to be done. Okay, so let's start revising this chapter based on the questions. So first question is, according to Woodrow Wilson, law is that portion of the established thought and habit which has gained distinct and formal recognition in the shape of uniform rule backed by the authority and power of the government. So Woodrow Wilson. Who was Woodrow Wilson? He was the president of USA and the architect of which treaty? Architect of Treaty of Versailles, and also the father of League of Nations. So Woodrow Wilson, he has described law. He says that law is a portion of established thought. So, which has got formal distinction means it is a formally accepted thing in the form of uniform rule, means law is a uniform rule which is there everywhere. It is law is present in each and every state of the world. It is present in even the state of a jungle also, where might survival of the fittest is the law. So law is everywhere and it is backed by the authority and power of the government. So the government of the state, it is backing it. So it is the definition of Woodrow Wilson, and in this context, in the context of the above statement, we are to write any four sources of law. So in this sense, we are to write any four sources of law. The sources of law are given on our book also. So let's take a quick glance of the sources. Sources are customs and usages, religion and morality, delegated legislation, scientific commentaries, judicial decisions, legislatures, and equity. So now let's revise this topic. This topic is given on page number 5.3, 5.4 and 5.5 of our book. So let's start revising customs and usages. Customs has been one of the oldest source of law. So custom is one of the oldest source of law. We can also say that custom is the oldest source of law. In primitive societies, social relations gave rise to several usages, traditions, and customs. Established customs were used to settle and decide disputes among the people. So, in the primitive societies, it means that when the state was not there, means a state of only nature was there, and when the people started living together, their living gave birth to several usages or traditions or customs. So when the customs got established, they started using settling the disputes of the people. So customs were practiced habitually and violation of customs were disapproved and even punished by the society. So now when the people they started obeying customs or traditions, they obeyed customs habitually. Means force was not there. It was their will to follow the customs. And when the customs were violated, it was disapproved by the society. Means it was not looked good by the society. And even sometimes the society punished the violators of the customs. The social interaction began working on the basis of established and customs and accepted customs. So all the social institutions which started working after the formation of society, for example, villages, families, clans, they accepted customs and they started working on the basis of customs. Gradually, the state emerged as the organized political institution of the people having the responsibility to maintain peace, law, and order. Naturally, it also began acting by making and enforcing rules based upon customs and traditions. So, firstly, when the institutions were formed, the first social institution to be formed was family. Okay, when family was formed, then it gave birth to extended families. Extended families then gave birth to villages or clans. So when the clans they clashed with each other to get more and more air gas, it gave birth to state. So when the state emerged, it had the responsibility to maintain peace, law, and order. So, at that time, constitutions were not there, legislatures were not there. So, what did the state do? It just started regulating the behavior of the people on the basis of established customs in society. All the customs, all the traditions which they were formed in society, they were accepted by the state, and the state started using these customs to maintain law and order and peace in the society. So it is the first point. Second is religion and morality. So customs and usages are the first point of the source of law. Second is religion and religious codes appeared naturally in every society when human beings they started observing, enjoying and fearing natural forces. These were accepted as superior heavenly forces, gods and goddesses, and worshipped. So, how did religion appear in society? Religion appeared naturally when the human beings they started observing, enjoying and fearing natural forces. What are the natural forces? For example, water, air, rain, thunderstorms, storms, rivers, oceans. So all these are natural forces. So when the humans firstly they observed these natural forces, for example, firstly the human beings observed that rain is pouring from the sky. So firstly it was observed. Secondly, man started enjoying rains in the summer seasons. But when the rains poured so heavily that it led to the floods, then he started fearing rains also. So all these natural forces they were accepted as heavenly forces, that heavenly force is there which is regulating all these forces. So these were accepted as gods and goddesses. Okay, whatever, whichever force could be treated as male, it was termed as god, and whatever natural force could be treated as female, it was termed as goddesses. So now the humans started worshipping natural forces. Religion then started regulating the behavior of people and began involving godly sanction, fear of hell, and possible fruits of heaven for enforcing the religious codes. So, when religion appeared in society, religion started regulating the behavior of people. How did it regulate the behavior of people? It started regulating the behavior of people by giving godly sanction behind any act, or fear of hell, that if you do something, or if you didn't do some if you don't do something, you will go to hell. And if you do something, or if you don't do something, you will go to heaven. So when the fear of hell and possible fruits of heaven were given to the people, people started using religious codes. It compelled the people to accept and obey religious codes. Several religions came forward to formulate and prescribe definite codes of conduct. The rules of morality also appeared in the society. The religious and moral codes of society provided to a state the necessary material for regulating the actions of the people. So, it was not that a single religion was there. Number of religions they were formed in society. So, when the religions were formed, naturally the rules of moral code of conduct they were also formed, and when the state emerged, it started regulating the behavior of people on the basis of religion. Several of the religious codes they were accepted for regulating the behavior of the people. So it is religion and morality. First point was customs and usages. Second is religion and morality. Third is legislation, statutes or statutory law. So, what are legislation, statute, or statutory law? It means the laws made by the parliament. Okay, so in the previous times, we know that kings were there, and the kings they just give decrees or orders and then started regulating the behavior of the people. But gradually, with the coming of democracy, legislatures were formed. Okay, so legislature they started making the laws. So in contemporary times, legislation has come to the most potent, prolific, and direct source of law. Legislation has come to be the recognized as chief means for formulation of the will of the state into authoritative and binding rules, values. It has been performing the role as a codifying agency for customary rules of behavior in society. So in the modern times, that is in contemporary times, all the laws which are made they are made by the legislature. Let's take example of India. In India also, all the laws which are made and which are enforced in Indian state they are made by our union parliament. So likewise in all other countries, or in major other countries, major part of the other countries, all the laws are made by the legislature. So legislature it formulates the will of the state. We know that will of the state means laws. So legislature makes laws, and all these laws they are binding on the people. So legislature it is taking the primary role in making the laws. So legislature is the chief source of law in the modern times. Next is fifth point we can write here, judicial decisions. See, what are judicial decisions? Judicial decisions are the decisions given by the the highest court, okay, or the courts. So in contemporary times, judicial decisions have also emerged as an important source of law. It is the responsibility of the courts to interpret and apply a law to specific cases. The court settle the disputes of the people in the cases that come before them. The decisions of the court are binding on the parties to the disputes. These also get accepted as law for future cases. But not all judicial decisions are laws. Only the judicial decisions given by the apex court or court which stand recognized at the courts of record, like the Supreme Court of India and High Courts of India, are recognized and used as laws proper. Courts can settle the future cases on the basis of such judicial decisions. So, in every state, several courts they have been given the title of courts of record. Okay, we had read it in 10th standard also, where Supreme Court and High Courts are the courts of record. So, what is the function of, or what is the work of courts? The work of court is to settle the disputes of the people. So when the court is settling the dispute of the people, it gives decisions. So the decisions given by the courts of record are binding on all the people. When the judicial decisions are given by the courts of record, all other junior courts are bound to give similar decision in the similar case. For example, if a dispute is solved by the Supreme Court, so as the Supreme Court is the court of record, all other high courts and subordinate court, that is the district courts, they are bound to give similar kind of decision in similar kind of case. And when we are talking about high court, they are also the courts of record. So when a dispute is solved by the high court, then all other courts which come under the jurisdiction of the high court concerned, they are bound to give similar decision in the similar case. So in this way, the judicial decisions, they also become laws. So it is the constitution of the state which is giving power of record, power of court of record, or a status of court of record to a particular state. And whenever the decision given by the court of record is there, it is binding on all the courts in the country or the state concerned. So these are the sources of law, dear students. Today we have revised the sources of law, and your homework for today is that you are to learn and write this question given in the class. So let's take quick round of questions. First is, which is the oldest source of law? It is customs. Customs are the oldest source of law. Second is religion and morality. When did religion appear? Religion appeared when people started observing, enjoying and fearing natural forces. Third is legislation. Which is the contemporary source of law? It is legislation. Judicial decisions. So which court's decision are accepted as law? The decisions given by the courts of record. So dear students, please, your homework for today is learn and write this question given in the class. Thank you so much.